Hello, and welcome. I'm Torres-Spelliscy, and this is 5 Minutes with the Professor. In this week's 5 Minutes with the Professor, we'll focus on contract law. I'll leave the more basic elements to your readings in the text. What I want to focus on is a particular aspect of contract law that is becoming ubiquitous, and that involves e-commerce. E-commerce has exploded over the last 15 years and is expected to grow into a $1.2 trillion market worldwide. In the US, online retail sales now account for over 11% of all sales and are the fastest growing segment of the retail economy. E-commerce is the future of business, undoubtedly, so we need to understand how it is regulated in the modern marketplace. So how does contract law deal with e-commerce? Well, it's based on the same core principles of offer, acceptance, consideration, legality, and capacity. The same principles you read about in your text. But these principles have to be adapted to this new way of doing business. First, let's talk about the offer. As a seller, you need to make sure that your offer clearly and unambiguously states the terms and the conditions of the agreement, whether that's for the purchase of materials, a license to use property, or simply even the use of a website. The offer must clearly state the terms. Why is it important? For the most part, online offers are made on websites where there's not a chance to engage in discussion about offer terms. It's your responsibility as a seller to make sure that the terms of your offer are clear. The offer should contain a hypertext or link, provide a pop-up window, or simply display the terms and conditions related to the agreement. We should clearly spell out how the buyer must accept the agreement, how payment can be made, as well as the return policy, if any, your company's privacy policies, and any limitations on remedies available if the goods are found to be defective, for example, an exchange or a refund. One thing to consider as an online retailer is the issue of jurisdiction. Your customers and business partners are likely to be from all over the world. You should give thought to adopting forum selection and choice of law clauses in your terms and conditions, which specify respectively in which courts or forums disputes will be heard, and what states' laws will be applied. Here, a prudent business person would also give thought as to whether to include an arbitration clause. Now, because there is no instantaneous communication between the seller and the buyer in an online transaction, agreement must be indicated by conduct. But that's not a new concept. Contract law has always allowed contracts to be formed via conduct. How do we do it in e-commerce? Best practices would be the adoption of a click-on agreement. I've included a short web video here about the different types of agreements and their legal validity. But here's where we run into a bit of a problem. One potential issue with electronic contracts is that there are new challenges to verifying the parties' identities because there's no face-to-face meeting. It is somewhat easier to fabricate an identity in an online setting. As a result, for years prior to the adoption of the e-Sign Act, some states required that certain contracts be in paper and others could be electronic. Each state had different rules, so this caused confusion and impeded interstate commerce. The result was the federal adoption of the e-Sign Act, which basically says that if parties agree to use electronic documents and signatures, that agreement will stand, whether or not contrary to existing state law. Essentially, the feds decided that if the parties wanted to contract in a certain way, the states shouldn't be standing in their way. A number of states followed suit, offering additional clarifications on how to authenticate identity through the adoption of the Uniform Electronic Transaction Act, the UETA. Together, these rules seek to eliminate any barriers to e-commerce by ensuring that electronic records and signatures are given the same legal effect as paper documents and written signatures. But there are regulations that companies must follow in complying with these acts. You must be able to demonstrate through your programs and software solutions that there exists, one, an intent to sign. This is usually done through the clicking part of the click-on agreement. There's a consent to do business electronically. That there's a way to associate the signature with the record, meaning there's a record showing that how the signature was acquired, the IP address, and other identifying information, proving that it was executed with electronic signature. And you must have a document retention policy. Now, there are many companies out there that are providing electronic document solutions, and if your business is going to be doing a significant amount of electronic commerce, you should really consider utilizing one of those options. And what if you need to change the terms of service of your agreement? Can you do that? Well, first, you should make sure that you have a term in your original TOS, meaning terms of service, that allows you to modify those terms and lays out the steps you will take in doing so. Typically, these are enforceable provided the company follows a few steps. Let's look at the issue by examining the 2014 case of Rodriguez versus Instagram. The case was centered on a change to the terms of service in Instagram's user policy, initiated after Facebook purchased the company and was looking for ways to monetize its membership. The new terms, among other things, gave the company a right to sub-license user pictures in advertisements. Now, the plaintiffs sought to form a class action and sue on the breach of contract as a result in the change of terms due to a violation of what they said was good faith negotiating. The court disagreed and found for Instagram in December 2012. Instagram had given its users notice that the TOS would be updated for the site as of January 19, 2013, and provided an opportunity to opt out by stopping use. The new terms said that if a user continued to use the site after that date, he or she would be deemed to have accepted the new term. The court found that the notification of the new terms and the ability to opt out were sufficient to establish that Instagram had acted in good faith and had not breached its contractual obligations. So as long as you have a modification clause in your TOS, you give notice and an opportunity to opt out, changes to the TOS are generally allowed. Well, that wraps it up for this week's 5 minutes or so with the professor. Let me know if you have any questions, and I will see you on the discussion board.